Hey, thanks, Dave. It's 6 minutes after the hour here. 84 degrees in Clearwater. High of 86 today and low of 70 tonight. We've got a brand new show here on the Tan Talk Network. It's starting right now. It's called The Legal Forum. If you have any legal questions, you can give us a call at 866-826-1340. That's toll free, 866-TAN-1340. Or give us a call locally. Just pick up 727-441-3000. 441-3000. And now, here's The Legal Forum with your host, Cedric Harris.
Hey, thanks, Lee. Appreciate it. It is The Legal Forum, and today we're going to be talking family law, as Lee mentioned. If you have a question, call us in studio, 866-826-1340. Today in the studio we have Caroline Black-Sikorsky, and Caroline has held numerous positions related to her practice area, including Fellow in the American Academy of Matrimonial Lawyers and past president of the Florida chapter, chair of the Hillsborough County Bar Association Family Law Section, and chair of the Tampa Bay Collaborative Law Group. She is AV rated by Martindale Hubbard and mentioned in the Best Lawyers in America 2013. She has been published in the Florida Bar Continuing Legal Education publications on family law. She is board certified marital and family law lawyer, by the Florida Bar Board of Certification. She's attended Cornell University and Stetson College of Law. Caroline, thank you so much for coming on the show.
Well, thank you, Cedric. It's a pleasure to be here.
Well, how about you tell us a little bit about your practice?
Well, I practice with my two partners and two other lawyers, and we practice marital and family law. That's all we do. Our practice is based out of Tampa, but we do Pinellas, Hillsborough, Sarasota, Manatee counties, and beyond.
Interesting. What kind of custody does Florida have? What is joint custody, for example?
We have something in Florida called shared parental responsibility.
Okay.
What that means is essentially joint custody. When I meet with clients, they always want to know, what is joint custody? What shared parental means is each parent has equal rights and equal responsibilities with respect to the child. Neither parent has a right to greater time with the child. And what Florida law says is we really want to encourage that. We want to encourage both parents to be actively involved. So they've taken away those labels that used to exist. One of those labels was primary custodial parent. We don't have that anymore. That was abolished about 6-7 years ago. And now we just have shared parenting with a time-sharing plan.
Interesting.
And the time-sharing plan is essentially what the parents agree as long as it's in the best interests of the children.
Right.
Sometimes we'll have something called a 50-50 timeshare, where the parents have the child 50% of the time. Sometimes it's a 30-70, 40-60, or all over the board. But there's no requirement. There's no legal presumption that one is better than the other. It's whatever is in the best interests of the children.
Okay, excellent. So what is a parenting plan?
That's a great question. We just passed a law about parenting plans, again, about 6 or 7 years ago, when they got rid of all those labels that really had no meaning. They started with this parenting plan, and there really are 3 or 4 accepted parenting plans that you can find online. You can go to our law firm's website. You can go to the Supreme Court Forms website. It is usually a 10 or 12-page document that sets forth the time sharing as well as other things. Who's going to pick the kids up from school? Who's going to take the kids to the doctor? What's going to happen for vacation or summers? All those sorts of things are in the parenting plan.
And where can they find that? What's your website?
Our website is www.m as in Mary, B as in boy, C as in cat, lawoffice.com. And then you'll have to look in the news section, or there's a research section, and you'll see parenting plans in there.
Interesting. Now, I've had people ask me this before, and I'm curious, can your children testify when you go to court?
Not without court permission. And the law basically says we don't want the children involved in their parents' conflict. And while it is important to get the child's perspective, it's not always an unbiased perspective.
Yeah,
you may have a parent who takes the child to Disney World immediately before somebody asks them, where do you want to live? So the courts have said, we don't want to hear from children. Now, there are some exceptions.
And what would that be?
They would be typically children who are of sound mind and who have shown an ability to know the difference between right and wrong and are not likely to be influenced by external factors. That can be typically a child who is 14, 15 years old. I have people who come in and say, oh, I heard my child can testify at age 12. There's no set rule. It's just a maturity judgment.
So is it more likely for it to be an older child, though?
Yes,
Okay.
much more likely.
Interesting.
Now, if you want the input of your child, one way to do that is to get someone who's a psychologist or a social worker or someone who's qualified in mental health and interview the child. And then that mental health person can come to court and say, well, I talked to this child. The parents weren't there. There was no outside influence. And the child has told me this. So that's one way to get the child's perspective heard.
Would it make any difference if both parents were interested in the child testifying, or if one does and the other doesn't?
That can be a factor in determining whether a judge allows a child to testify. So if both parents want the child to testify, and there still has to be that maturity level, the judges probably are more inclined to do that.
Okay.
But some judges are very cautious, and they know that if one parent wants something, or even both parents, there may be a better way to find out what the conflict is all about, rather than putting the child on the witness stand.
I can imagine that could be very traumatic.
It could be very traumatic, yes.
What is a custody evaluation?
One way courts determine what the time-sharing schedule would be is to use a mental health professional. That could be a psychologist. That could be, there's some courts, the larger courts, the courts that are funded with more resources, they have case management workers and social investigators, and you can use the court system sometimes to find the appropriate person. But you hire someone to do a complete investigation of the parents, the children, and the significant people involved in the child's lives. That may be a teacher, that may be a nanny, that may be a significant relative that has to come in and talk to the mental health professional. And that mental health professional will then conduct tests. There's psychological tests that are acceptable in court. And then this one person, this mental health professional, takes a look at the tests, takes a look at the interviews, takes a look at a bunch of other factors, and then makes a recommendation to the court as to what's appropriate for time sharing.
Okay. Now, can you tell me, first of all, do you need a guardian ad litem? And for some of our listeners, what exactly is the role of a guardian ad litem?
A guardian ad litem is someone who's appointed by the court to represent a certain person's interests if they're not represented by a lawyer. In family law cases, that's typically the child. And sometimes if a parent or both parents are in what we call high conflict, the judge may say, this child needs some protection. This child needs a guardian ad litem. So they'll appoint a guardian ad litem, and all that person is a sounding board and an investigator on behalf of the child, and their sole duty is to represent what's best for the child, not to do what one or the other parent wants, but to look into the situation and to really be very specific about the child's interests. So can the court appoint a guardian ad litem? Absolutely. It's not typically done unless it's a very high conflict case.
Interesting. So this would be somebody that has no relation to the family or the situation whatsoever.
Correct, yes.
Interesting. Now what's a parenting coordinator?
That's something completely different. And, you know, in family law, we have all these people who circle the family. Each person's goal is the same, to protect the family, but how they do it is different. The parent coordinator, it's typically somebody who becomes involved in the case, usually after the divorce, but it doesn't have to be. And that's for parents who continue the conflict beyond the divorce.
Mm-hmm.
One of the studies that I've heard and been told by psychologists shows that children of the divorce can have a normal life and can adjust properly to the divorce, but where parents continue their conflict beyond the divorce, those are the children who are really at risk. Those are the children that have trouble adjusting and have trouble in school. So the parent coordinators are appointed by the court, either by agreement of the parties or by a judge, and that parent coordinator's role is to say, okay, we have a dispute. Why isn't the child's sporting equipment getting back and forth between the houses? Why isn't the child allowed to play baseball when their child is with one particular parent?
Right.
Those types of issues. And those are the issues that really do cause great conflict, great stress for the children, and a parent coordinator has some authority to sort of mediate and try to resolve those issues.
Okay, thank you so much. Now, this is the Legal Forum. It's a brand new show. If you've listened in this time slot before and haven't heard it, we just started today. We're talking to Caroline Black Sikorsky about family law. If you have any questions, you can call us here in the studio at 1-866-826-1340, and Lee will take your phone call. We don't bite. Now, a question that I'm sure a lot of people have is, can you move after the divorce? I assume you probably can't during the divorce process, but afterwards, can you?
Well, the answer is you can move with court permission always. The statutes in Florida specifically say if it's post-divorce, meaning that you have an agreement with your former spouse and each one of you lives in the area, you are not allowed to move more than 50 miles outside your current residence if you have children together without either court permission or the other former spouse's permission. So in that scenario, the judge, if there's no permission, the judge will weigh the factors of what is the reason for the move, how far away is the move, what is the relationship between the child and the parent who are moving, what is the relationship between the child and the parent who's not moving.
Right.
And what is the substitute time-sharing schedule going to look like? If a parent is moving to Miami, that's going to be a lot different schedule than if a parent's moving to California.
Right.
So all those factors get weighed into the issue of whether or not a parent should relocate. And there have been decisions where one parent has decided to relocate to remarry, say maybe an old high school sweetheart, and they're going back to their home state, and they want to go back and be with family. But the relationship between the child in Florida, who let's say is 5 or 6 years old, and the parent who lives in Florida is a very good one.
Right.
And there really isn't some adequate substitute time sharing. And in those situations, the judges will say, you cannot relocate. So you can relocate in the midst of the divorce too, but you still have to do the same type of analysis. What's the reason for the move? Where are you moving to? And so you still have to follow the same statutory restrictions.
Now, after a certain period of time, can this be reevaluated?
Yes, it can be, absolutely. If you are not permitted to move, and then there is a period of time that passes, and then you want to move again, you can try again. Maybe circumstances have changed, and so that would give justification for moving again.
Interesting. Is there any sort of limit to that, or?
There's no limit on to how many times you can try to move, but you do have to have a substantial change in circumstances in terms of your round one trying to move and round two trying to move. You can't just say the same thing over and over again.
Exactly. That makes sense. Here's a big one. How is child support calculated?
In Florida, we have a mathematical formula that the state legislature passed 20 plus years ago that calculates child support. It's based on income and the amount of time a child has with a parent.
Mm-hmm.
If a child has more than 20% overnight with one parent, the child support is what we call substantial time sharing. And most everybody's formula is a 20% or more time sharing. So the rules regarding child support are you calculate what the income of each parent is. If there's a support obligation like alimony, you have to factor that in as well. Then you count up the nights that each parent has the child over the course of a year, plot out that percentage, and apply this formula. And that's the child support amount. It used to be that the child support amount would be different if a parent had more than 40% overnights. So that meant that parents who had 40% or more were paying less child support. And then what happened was a lot of parents were trying to negotiate for 40% or more overnights to decrease their child support. A few years ago, the state legislature said that's not really what we intended to have happen, and they lowered the threshold to the 20% rule. So anybody who gets 20% or more overnights, the child support's all the same. And now you don't have these arguments of, I want 41% overnight. And thankfully that's been resolved.
Is there a common arrangement that you see?
There is no real common, but it is, I would say that there are sort of a couple of common arrangements. Until a few years ago, it was very rare, and I say 10, 15 years ago, it was very rare that you would see a 50-50 timeshare. You see that much more frequently. It is not the majority, but it is a much higher percent than it used to be. The other very typical scenario is something close to between 65-35 to 60-40. And that really depends on each parent's schedule, whether they both work or not, where they live, how far apart they are. When trying to figure out the time-sharing schedule, one of the things that the courts look at is how many back and forths are there going to be between each parent. Each back and forth is what we call an exchange.
Okay.
The fewer the number of exchanges, the better, because it just means less distraction for the child, less having to remember what goes in your backpack, what's at school the next day, making sure you get the right shoes for the right sport. All those things
less room for error.
Yes, exactly. And it's the child who gets penalized sometimes if all their stuff doesn't go back and forth.
Wow.
So,
more importantly for the parents, how long does the child support last in the state?
in Florida, the child support lasts until age 18 or graduation from high school, whichever last occurs.
Really?
In some instances, it can go to age 19 if a child got held back a year or something, as long as there's a reasonable expectation that they're going to graduate, but it can never exceed 19 years. So 18 years, high school graduation, but no later than 19.
So, and that would be something that the court would determine if there's a reasonable...
Correct.
Okay,
yes.
Interesting.
Yes.
How about college?
Well, under Florida's laws, college is not considered a legal obligation of either parent. It is not a child support obligation. That doesn't mean parents don't agree all the time about what to do about college, because remember, everybody wants to do what is the best thing for the child. So when we work on these cases and try to work through some sort of a settlement proposal, we do discuss who's going to pay college. And you can put it in the contract, the settlement contract, that one parent or both parents are going to agree on college. Certainly it's a much easier decision to make when the child is 14 or 15 and everybody knows what financial resources are available, as opposed to when a child is younger, maybe 3 or 4, and there's a long way ahead in terms of the finances and in terms of how this child is going to progress in school and how well they're going to do. So it gets a little more difficult to reach an agreement on college when the child is younger.
Okay. Now, if a parent has already set something in place for college, is that going to affect any court decisions with regards to custody or anything like that? Will it sway the opinion?
No, it really doesn't. What a court's going to do is say, if a parent has set aside money for college, that just means that's a good parent. That's a parent who either is fiscally conservative, loves the child, and is aware of things in the future that need to be saved for, And so does that make that parent look like an appropriate parent? Yes. But that's what every parent should do. So you don't necessarily get great points for doing that, but it is a good thing to do.
That makes sense. Can you tape phone calls between your spouse and the child or children?
You cannot tape phone calls between anybody in Florida. There is all sorts of federal wiretapping and telecommunications violations there. The only situation where you can do that is by consent. So
And I don't suppose that would go over very well. Hello, you're being taped.
It usually does not. Now, with iPhones and all of the camera phones that we have nowadays, people are taking pictures.
Mm-hmm.
You can always take a picture.
Right.
You just can't tape the audio.
Interesting. Can you limit the number of phone calls between the children and your spouse?
You really cannot limit the number of phone calls. Florida very much believes in encouraging communication between the child and the out-of-house parent. You can, however, make sure that the parent who's calling is doing so in a reasonable way. If there's one parent, perhaps there is an overprotective parent who's very anxious, wants to know how the child is doing all the time, calls incessantly. That's the sort of thing where a judge will perhaps say, let's get this on a regular routine. If you want to talk to the child every day, no problem. But let's make it at a time that's realistic and healthy, and that's what they'll do.
Interesting. Is there a standard custody plan?
There really is not a standard custody plan. What we have is the parenting plan we talked about, and then it's a form that you actually fill in the blanks. So there's nothing standard, but there is the contract that needs to be filled in.
Okay. Will the children be able to stay in private school?
If there's been a regular pattern of a child attending private school, or if there's been a regular pattern of the parents attending private school, and it's financially feasible after the divorce to continue the child in private school, and if it's something that is in the best interests of the child, that there's a specific need for the child, and that's somewhat nebulous. It isn't really a need that I need to go to private school, but there's some piece of an attachment or connection to private school that makes sense, then yes,
Okay.
absolutely.
So I suppose if all of a sudden they were going to private school and then one parent chooses to yank them out, that might
That's a bad move.
raise some red flags.
That's a very bad move, yes. A judge would be very unsettled by a parent taking a child out of private school unless there was a good financial reason to
Right.
do so.
Now, does the court have any decisions over what school the children go to?
Typically, the courts want the parents to work out the education of their children because the parents are the best people to make that decision. So a court isn't going to select the school. There are situations, however, where if the parents can't agree on the school, for example, there has been years of conflict and this child has been yanked back and forth between school A and school B, a judge may say, okay, I'm not going to decide what the school is, but I'm going to give mom ultimate decision-making authority to pick the school. We're going to stop this conflict now. Mom, you pick the school. Dad, you live with it. So you can have that result. Again, there has to be a history of that high conflict and bad behavior.
And now, can your spouse hide the children from you? I guess that's
No,
obviously
yes.
a no-no.
Right. You can't hide the children. You can't take the children without permission. There is, it's sort of like each parent has 100% rights to their children. So if one parent has the child and doesn't tell the other child, that's a violation of shared parental responsibility. On the other hand, it doesn't mean that one parent couldn't go to the school, even though, for example, it's Wednesday, and Wednesday is Mom's Day. It doesn't mean Dad can't go to the school and visit at the school. Dad can't pick up the kid and take the kid out of school because it's not his day, but he can go visit with the child.
Can the parents make arrangements outside of the court's decision?
Yes, they can, absolutely, and it happens all the time. There's so many variations of parenting that the courts don't want to be involved in. They want the parents
That's
to resolve
good.
those.
That's good.
Right. So, yes, you can deviate from either the agreed-upon schedule or the court-ordered schedule, but be aware that if there's a deviation and then there's a statement that, well, I never agreed to that, you need to have some proof that
Right.
this was an agreement.
I'd imagine you want to get that in writing.
Absolutely. By text, by email, whatever works.
Okay, we're talking to Caroline Black-Sikorsky. I got that right?
You did. Thank
Okay.
you.
And if you have a question for Caroline, you can call us in the studio at 866-826-1340, and we'll answer your family law question. Now, if they want to contact you off the air, and if they have some
Sure.
issues and they're thinking about consulting an attorney, how can they contact you?
They can contact me at my office, 813-251-9200.
Okay. And do you have a website again?
We do. We have a website, and there's an email on the website. I'm not sure it's my email, but there is a email, and the website is M as in Mary, B as in boy, C as in cat, dash,
Okay.
lawoffice.com.
Okay, excellent. Can we talk divorce?
Absolutely. Let's talk divorce.
Okay. What is the difference between a legal separation and a dissolution of marriage?
Florida is one of the states that does not have a legal separation. There are states that do. I believe it's North or South Carolina that you have to be separated for a period of time before you can actually get a divorce.
Really?
And Illinois is also similar. You have to have a separation of maybe it's a year, a physical separation. It's a defined legal status in those states, which leads to various different statuses and decisions. But the bottom line is Florida doesn't have it. You're either married or you're not. So you can physically separate. You can have a separation agreement in Florida, but there's no legal status defining legal separation like some other states have.
Okay. And what are the issues resolved by a dissolution of marriage?
Hopefully all issues, and that would include the equitable distribution, or what we call the property distribution, the alimony or the support provisions, the child support provisions, the shared parental responsibility, and last but not least, the attorney's fees and costs issue.
Interesting. Does it matter who files first?
It does not matter who files first. There's no legal significance to who files first. There is a reason to file. The filing of a petition for divorce is basically like stopping a stopwatch. The start date of the stopwatch is your marriage, the day you got married, and the ending date is going to be the date you file. And that's what we call the cutoff date. It's the date at which assets are cut off from being included in the marital estate. So if, for example, you are planning to buy a building and you don't want to part ways with your spouse with that building, you would file and then buy the building, assuming you weren't using marital funds to buy the
Okay.
building.
Interesting.
So the filing date has significance, but not who files first.
Interesting. I'm sure this varies, but how long does the divorce process usually take?
It does vary. Those cases that settle are somewhere between 3 to 4 to 5 months, sometimes 6 maybe. Cases that go to trial are anywhere from 8 to 12 months. Very high conflict cases where every issue is litigated with every resource. Those can go upwards of 2 or 3 years.
Okay. Would custody issues be involved in the divorce process?
Yes, they are. That's we've used that term custody, and that's sort of a generic term. Florida's term is shared parental responsibility. Yes, that is absolutely one of the first things that the courts want to dispose of. And it's fairly often that children's issues do get resolved separately. You sign the parenting plan, it's a done deal. But you can't resolve the issues of alimony or property or, who should get the very important sword or the pet dog or cat. So,
What is discovery and document exchange?
once a petition for divorce is filed, the parties are, and there's service of the petition, and the other side has to respond. The next stage, that's sort of the filing stage. The next stage in the divorce process is what we call the discovery phase. It's where each party has an obligation, a duty that will be enforced by the courts to exchange financial information. That means if you have a job, you got to hand over your paychecks. And it isn't just one or two, it's a whole bunch. Mm-hmm. It means if you own property, you need to turn over documents that show if you rent it, what the rental income is, if there's rental expenses, what those expenses are. If you bought it, you need to send over the closing statement. There is a whole laundry list of documents that Florida requires each party to send to the other. Now, many times parties say, well, I already know all that stuff. But lawyers know that what you think you know isn't always really the case. And so we require those documents to be exchanged, and that's that discovery phase. That generally it can take 3 months, it can take 6 months. It just depends on how much documentation there is and how cooperative everybody is. I know of cases where the document exchange has taken 10 to 12 months.
Wow. What is mediation?
Mediation is a great way to try to resolve all the issues in your divorce. It's what we call alternative dispute resolution. It means going to a qualified mediator, someone who does a lot of family law cases, because there really is a specialty in these family law cases. And each side shows up with their lawyer. If they want, they can bring an accountant, or if they want to bring a loved friend, they can bring that person too. But the point is you're going to meet to try to settle your case. And you're going to bring the resources you need to that mediation to try to settle your case. And if you have a really good mediator, that mediator knows whether the two people should sit together in the same room or whether they should be separated and kept separate. And we call that caucusing.
Okay.
And that's when the mediator just literally goes back and forth. They'll go to the mother's side and ask, what do you want me to say to the other side in terms of an offer? They'll deliver the offer to the other side, and the dad will say, well, I don't want to do that. And here's my response. And then the mediator gets to know what the issues are and tries to help the parties reach a compromise. You know, that's a little more of a professional way of doing what we call sometimes the kitchen table discussion.
Okay.
Where mom and dad sit down. They try to work it out between themselves. But either one party doesn't have the knowledge or the sophistication, or they just can't reach an agreement. So you can then use a mediator to try to resolve those things.
Okay. Can you tell us about arbitration?
Yes, arbitration is another alternative dispute resolution where instead of going in front of a judge, you get an arbitrator who makes the decision for you. It's not commonly used in family law. A lot of people ask about it, but it's not something we've done very frequently. It doesn't mean we couldn't, but it's a lot like going in front of a trial judge and trying a case in some ways. In some ways, it's a more abbreviated procedure, but again, it's really not used very often in family law.
And what is collaborative law?
Collaborative law is another means of trying to resolve your case. It's a new form of alternative dispute resolution. When I say new, I mean it's only been around 20 years or so.
Okay.
It's fairly specific in terms of the requirements that you have to do for it to be collaborative law. It means that each party hires a lawyer, and those two lawyers and the parties sign a contract. They will not go to court.
Okay.
They will not file any motions. They will not have any subpoenas issued. They will not do depositions unless the group as a team agrees to do that. In addition to each party having a lawyer, there's going to be an independent financial neutral, usually an accountant, and an independent mental health professional who acts as a facilitator. As I'm sure you would guess, these collaborative meetings can get heated, very emotional, and the dynamics of the relationship sometimes take precedence over common sense. So you have your mental health professional who knows when to step in and say, let's have a timeout, and then can say to the parties, listen, what are you really trying to accomplish here? If your goal is trying to get some amount of money you can live with, is what you just said going to get you there, really? So, and then the financial professional is the person who looks at both sides' financial documents and comes up with a reasonable valuation, and there's all sorts of financial issues, but they come up with a reasonable approach. If there are issues about, questions about certain assets, they address those. And they, again, you come to the collaborative table, you talk about all these things, and you don't reach a decision on anything. Minor issues, major issues, partial issues, final issues, until everybody agrees. It's really a wonderful way of trying to resolve a family law case.
Interesting. What standard does the court use in determining who gets what assets?
In Florida, again, we have what I said was equitable distribution.
Okay.
Now, equitable pretty much means equal in terms of the marital estate. In Florida, we have something called non-marital assets or marital assets. And the marital assets are, remember that stopwatch? We started at the date of marriage, and then we stopped at the date of filing. That's the marital estate. And whatever was in existence in the marital estate is going to be divided pretty much 50-50. If there's a non-marital asset, it could be an old piece of furniture you brought from your days before you were married, or it could be an inheritance of some kind where one person inherited money from a grandmother who died. But there are some things that can be non-marital.
Okay.
So that's usually what the courts do. They set aside the non-marital assets to each party and divide the marital assets 50-50.
All right, we're talking to Caroline Black Sikorsky. We're talking family law today. This is The Legal Forum, brand new show. You can call us here in studio at 1-866-826-1340. We're going to take a quick break, and we'll come back and talk more family law with Caroline. Thanks.
Joffrey Fashions, located at 8 South Fort Harrison in downtown Clearwater, is presenting a fabulous fashion show at this year's Cars and Couture, Friday, October 18th at 9:30 p.m. Cars and Couture, a fashion for charity event, will be at the Tampa International Jet Center and benefiting Autism Speaks. Enjoy live music, cocktails, fine cigars, a silent auction, a fashion show, and much, much more. That's 9:30 p.m. on Friday, October 18th at the Tampa International Jet Center, 4751 Jim Walter Boulevard in Tampa. See the Joffrey Fashions presentation at Cars and Couture and visit Joffrey Fashions, located in downtown Clearwater, for fashion at its best. Joffrey Fashions, 8 South Fort Harrison, next to Starbucks in downtown Clearwater. And for more information, contact Joffrey Fashions at 727-442-4172.
Tantalk Traffic now a service of 5 Star Auto Sales today. State Road 50 bypass through Brooksville. We are looking southbound 75 at Lamp Brandon area around Highway 60 for a crash. Northbound 75 at mile marker 275. Some activity there as you make your way up towards State Road 54. Other than that, we're in pretty good shape. For first-time buyers to the credit challenged, you need a vehicle you can rely on. 5 Star Auto Sales has guaranteed credit approval with down payment and provable income. You deserve a second chance. Stop by 5 Star Auto Sales today. State Road 50 bypass in Brooksville. Dave Anderson on the Tantalk Network.
Thanks, Dave. 46 minutes after the hour, 84 degrees here in Clearwater. Clear tonight with a low of 70. Welcome back to the Legal Forum. Today we're talking about family law with Caroline Sikorsky. If you want to call in, ask any questions, our local number, 727-441-3000, 441-3000, or toll free from anywhere, 866-TAN-1340, TAN 1340. Back to our host, Cedric Harris.
Hey, thanks, Lee. I appreciate it, man. All right, we're talking to Caroline Black-Sikorsky, and you can email her if you have any questions that you don't want to talk about on air. I totally understand that. It's caroline@mbc-lawoffice.com. Now, we were talking about property issues. Who is going to pay all the bills during the divorce process?
When someone files for divorce, that's, again, you have your filing stage, the filing has occurred. The next issue always comes up, who is going to pay the bills? And typically speaking, it's going to be pretty much whoever paid the bills before the divorce was filed. There is a legal obligation for the person who makes the more money to continue to pay those bills. So if you have one who stays at home and the other who works, the primary wage earner is going to continue to pay those bills. It's something to keep in mind when deciding if you're going to go out and leave your home and move into an apartment. You need to know that you're going to be still obligated to pay the temporary support, which is the bills that were typically incurred during the marriage.
Okay.
If there's two parties who both work and can both contribute to the bills, then they should both pay. And that's what courts spend a lot of time on. They have a lot of hearings on temporary support because people disagree on who should pay what. There's also the situation where sometimes people will start to run up the credit card bill. And
is that very common?
it is. Yes, it is. Yes.
Wow.
They have a need for things or for even support. It happens where people run up the bill, or it happens where people put things on credit cards because now the spouse, the other one, cut them off and says, I'm not giving you any more money. And so then the credit card bill goes up because somebody didn't pay the bill they said they would pay or typically paid.
Right.
So temporary support issue is a very fact-driven scenario. And so all I would tell people listening is there is a rule that the bills have to get paid while the divorce is pending. And if there's some issue with someone not paying it, they need to know that whoever's supposed to be paying it is supposed to pay it, and to talk to their lawyer about it.
So what's going to happen to the home while the divorce is still pending?
Normally the home continues along the way that it normally does. The bills get paid. The home does not have to be sold if it's financially feasible for the parties to maintain it. And that's during the divorce and post-divorce. So what typically happens is everybody stays in the home, or one side stays in the home, the other moves out.
Okay.
And then when the divorce is final, you take a look at what are we going to do with the house? Does it make sense to keep that house? Is the payment that I would get in some apartment more expensive than the mortgage I'm currently paying? Is it financially feasible to keep that house for at least one side? So that's the determination, financially feasible.
Okay, now what about retirement plans? Are those going to get divided up?
Yes, they will. And that includes IRAs, if people have an IRA. It includes 401k plans. It includes defined benefit plans. And it includes military retirement plans. One thing that is unique to family law with retirement plans is the tax issue. If you were to divvy up a retirement plan today, you'd get penalized by the IRS because you're not allowed to touch it until you retire.
Right.
But in divorce, the IRS has an exception. If you're getting a divorce, we can split that 401k in half without any tax consequences. There just has to be a legal document. We call it a quadro, which is short for Qualified Domestic Relations Order. Once you have one of those, the tax man will not cometh.
Does Florida recognize separate property?
Florida has what we talked about earlier, the non-marital property designation. It's the same thing as separate property, and a lot of people use that terminology, separate property. It's essentially non-marital stuff.
What about prenups? Can they be contested?
If a prenup was entered into and all of the rules that were followed that are set forth and say, in order to get a good prenup, you need to do A, B, and C. If you follow all those rules, it's very difficult to set aside a prenup. Now, if you're the guy, you're getting married, and you're marrying someone, and you walk up to her the day before the wedding and say, sign here, that's not following those rules.
Okay.
The rules require there to be sufficient time for the parties to really think about the financial issues. They require full financial disclosure so that everybody gets an awareness and an understanding of what the assets, liabilities, and income are before signing off on the dotted line.
Okay. This is The Legal Forum on the Tan Talk Radio Network. We still got about 9 minutes. If you have any questions for us, the number in Pinellas is 727-441-3000, and toll-free anywhere, 866-826-1340. And if anybody wants to contact you off the air again, what's a good way to contact you?
The easiest thing to do is to email me at my email, which I think you read off. It's Caroline at mbc-lawoffice.com. And again, we can't give legal advice, but I'm happy to pass on whatever emails people send me in some appropriate response that I can give. I can't comment specifically on their case, but I can give them some ideas or suggestions.
Okay, now we have some questions about alimony. How does the court decide whether somebody should be awarded alimony?
The court's going to decide alimony based on the length of the marriage and a few other factors that are, there's actually, I believe it's 7 or 8 or 9 factors now in the alimony statute. There are essentially 4 types of alimony. We have something called bridge the gap. We have something called durational. We have permanent, and we have rehabilitative. Bridge the gap alimony is typically for a short-term marriage, something in the neighborhood of about 3 years, 3.5 years. You're not going to be ending up paying alimony forever and ever and ever. You may end up paying alimony if there's an income disparity and there are all the other factors. So if you get bridge the gap, it's a very short term, it's a very limited amount of money, and it's literally designed to help you bridge the gap from married life to being single again. Sometimes it's as simple as enough money for you to move out, put deposits down on a new place, and get a couple of months of expenses under your belt. So that's bridge the gap.
Interesting.
There is rehabilitative alimony. That alimony is designed to pay people to go back to school, to become educated, to be able to get a job and enter the workforce. So that's rehabilitative alimony, and that's typically based on how much time, how much money is it going to cost for you to rehabilitate yourself and get a job.
Okay.
Durational alimony. This is new. This has only been around for 3, maybe 4 years now.
Really?
And it is specifically designed for marriages that have been in length of 7 to 17 years. In that time frame, if you've been married, then you can get durational alimony up to the length of the term of the marriage. So if you've been married 12 years, you could only get alimony up to 12 years. Doesn't mean you're going to get 12. You might only get 8, but you cannot get more than 12. If you've been married for more than 17 years, then you're entitled to permanent alimony.
Oh.
Yes, and there's a lot of people who have that very same reaction. That word permanent just strikes fear in their hearts. It's alimony that's paid until the payor dies, or the recipient dies, or the recipient remarries. So I have a lot of clients who try to set their ex-spouses up on dates with people. So in order to get that determined.
And so there's no reconsidering that after a decision is made on alimony?
The answer is likely no. You can always come back and ask for a modification of your alimony, and you can come back and ask for a characterization of it from perhaps one to the other kind. But those are difficult, and there are certain criteria that you need to meet in order to do that. And usually it has to do with some inadequate award at the time the original divorce was entered into, some perhaps good luck of somebody winning the lottery, and now there's a lot more money available. So,
And is that alimony reform? What's alimony reform?
alimony reform is a new movement in alimony, and it is a potential for the alimony statutes to be changed. Last year, there was a group called the Florida Alimony Reform Group, and they tried to terminate or eliminate permanent alimony.
Okay.
They were not successful. They're going to try again this year, and we will see what happens. But there are bills pending in committees to eliminate or terminate permanent alimony.
Okay. Am I going to have to get a job?
If you have the ability to contribute to your own support, yes, you might have to get a job, and it is possible that a court will consider that to offset the amount of alimony that you should get. So if you earn nothing and your spouse earns a lot, your spouse is going to pay you money. However, you could contribute to your support maybe $20,000 a year. So that'll offset the amount that your husband would pay you because you could get a job. You don't have to. Nobody's forcing you to. But the amount of alimony you get is going to be after you have your own job.
Okay, interesting. Are experts necessary?
They can be, and they can be very expensive. It's something you should talk to your lawyer about in determining the necessity of them. I use CPAs all the time.
Okay. Isn't my spouse going to be responsible for paying for health insurance after the divorce?
Potentially, but typically not. There is an alimony claim that builds in the need for health insurance. So what typically happens is the alimony includes the cost of the health
Interesting.
insurance.
We're running low on time here. What else can you tell our audience that would be beneficial, that really, if they don't take anything else away from this, what would you tell them?
I get a question a lot. Can I get my spouse moved out of the house? Can I kick them out? And the answer is no, not without some sort of domestic violence allegation that is truthful. And so you cannot require a spouse to move out of the house. It makes sense from a financial point of view because not everybody has enough money to pay for two households, much less one.
Okay.
But if there is some real detriment to the children for both spouses to be in the house, again, the high conflict case, there is potential for somebody to be asked to leave the house.
Okay. We've been talking to Caroline Black Sikorsky. Really interesting stuff. One more time, can you give us your contact info?
Absolutely. You can get me at the website, which is www.mbc-lawoffice.com.
Okay, thank you so much. We'll have to have you back again to talk some more.
Thank you.
This has been The Legal Forum on the Tan Talk Radio Network. Tom O'Brien's coming up next. Thanks, Lee. Cedric Harris here, signing off. We'll see you next week.
WTAN, Clearwater, Tampa Bay. WDCF, Dade City, Tampa Bay. WZHR, Zephyr Hills, Tampa Bay. Listen.